Thank you. Thank you so much. Very glad to be here. As you heard, I am Daniel Mark, and I teach at Villanova. This is actually, as Dan said, the book was just published late in the summer, and so this is actually my very first book event. Given that it's this special occasion, I'm going to take a little bit of privilege, which fits in because Dan said that we weren't doing literature at this event, but I have a surprise for Dan. We're still doing, and I'm not referring to my book. My book is not. It looks pretty, but it's not literature. And I want so as I say in the acknowledgement. As I say in the acknowledgements, the book, of which this is my first event promoting, is dedicated to my two sons. The book came about, especially at the end, in a period of enormous personal trial that almost broke me, but my world revolves around my boys, and the book and everything else I do, as I say, is for them. And I quote in the acknowledgements, which I'll quote in full here from the literary masterpiece, Horton Hatches the Egg. At the climax of the story, if you're not familiar, you should refamiliarize yourself with it. Did he run? He did not. Horton stayed on that nest. He held his head high and he threw out his chest and he looked at the hunters as much as to say, shoot if you must, but I won't run away. I meant what I said and I said what I meant. An elephant's faithful 100%. The other reason I wanted to do that here today, besides it being my first book event, is that Dan Shealy, who directs Collegium, and his wife Kaysen are longstanding friends and were as faithful friends as one could imagine and ask for. Dan's talent and wisdom in directing Collegium is surpassed only by his extraordinary character as a man and as a friend, and along with his wife Kaysen as well. And so I owe an enormous, not only professional debt of gratitude to Dan for putting this together for me, but an even more enormous personal debt of gratitude. None of which, to be sure, is an excuse for any shortcomings of the book. I own those. Whatever's wrong with the book is just my own. But thank you truly to Collegium, to Dan, to everyone from Collegium. Thank you for the kind introduction, and thank you to the panelists who drew the short end of the stick and had to actually crack the book to prepare some comments. I'm going to try to do three things. And here, first, just tell you a little bit about what the book's about, kind of what motivates the book, what the jumping off point is for the book, say a little bit about why the book might matter for scholars. So anybody here has an academic interest in the book is interested here because we were friends or colleagues at some point, which I really appreciate. And then why it matters for the rest of us. I'm not a real scholar, just play one on TV. And so, something of general interest as a final enticement for anyone who wants to take a look at the book. So what's the book about? Part one. Well, as I say in the opening, I like to joke that legal philosophers mainly care about two types of law: traffic laws and Nazi law. And now you can skip the first line of the book. And so I offer you the case of the mythical traffic light. You come to, it's not going to happen downtown here in Philadelphia, but maybe a few miles past Villanova, you come to a traffic light in the middle of the night, in the middle of nowhere, and there's no one around a clear view for miles in every direction. The question is, do you need to stop at that light? So, okay, show of hands. Who's stopping at the light? Middle of the night, middle of nowhere, clear direction. Wow, okay, this is an obedient bunch. I like it. It bodes well for Q&A. Traffic laws are a really good example that legal philosophers do in fact love because there is nothing intrinsic about their specifications. So this is a realm of law that Aquinas called determinatio, that Blackstone calls matters of indifference. it's good to have safety at intersections, safety among other things, but whether we have a traffic light or a roundabout or a stop sign or a yield sign or just kind of a general understanding in our community that everyone will proceed through intersections carefully. I don't know, I have never bothered to actually look this up, but this kind of a maybe real, maybe apocryphal story about a fairly dangerous intersection. And they decided at some point in that locale to remove the traffic light or the stop sign or whatever was there. And the intersection actually got safer because everybody driving up to the intersection knew that they actually had to proceed with caution as opposed to just kind of relying on some kind of external system to do it. But in the meantime, here we've got a group of people who would be stopping at that traffic light, and I assume that you acknowledge if you are going to stop at that traffic light, that you only have to stop at that traffic light because there is a traffic light. That if there were a yield sign, maybe you'd slow down, look around, wouldn't necessarily have to stop. If there were no sign at all, again, you could proceed with caution, but certainly proceed without stopping. The orange or whatever, I'm colorblind, but the orange flashing light we sometimes see in lieu of a red light in the middle of the night. Also, right, proceed with caution, don't have to stop. We're only stopping because there is a red light. Now, as a mini lesson on the side here, I want to be very clear that this is, in fact, I was reading this literally with reading Finis with students this morning, commenting on Aquinas, making the point that this does not mean that these kinds of laws, these aspects of the positive law, as we call it sometimes, are disconnected from the natural law, from morality. There are moral principles behind the traffic light. For example, we have concerns for safety at the intersection, that nobody should die, a pedestrian or in a vehicle, a motorist going through the intersection, but also for efficiency, right? We want to keep things moving in an efficient way because it's important that people get from A to B. And those are values, those are moral principles that we have that inform our decision. But the specific decision about having a traffic light is not one that is determined by any objective moral principle. So the example of the mythical traffic light is a good example, to return to where I was, because there's nothing intrinsic about that. There is no reason, and in the case of the mythical traffic light, the one in the middle of the night, there's no reason to stop other than the fact that the light is red. By stipulation, again, there are no pedestrians, there are no animals, there's no other cars, there's nothing else around that would create any kind of danger, and so you've got no reason to stop other than the fact that the light is red, and so it allows us to ask the question in its purest form, as it were, is there an obligation to obey the law just because it is the law, right? And that wouldn't apply, let's say, to laws around theft. So if there's no law criminalizing theft, I've still got a very good reason not to steal from someone, irrespective of the fact that there's no law. In the case of the traffic light, that doesn't exist, right? No traffic light, no reason to stop, even if there's a reason, as I say, to proceed with caution. And my answer to the question, is there an obligation to obey the law just because it's the law, is yes. Or at least probably. In the book, I say yes, but among friends today over lunch, I'll give you a strong probably. And the centerpiece of the book is my definition of law as a set of commands oriented to the common good. Again, I'm going to define law as a set of commands oriented to the common good. Now, not least because we are the guests of the Collegiate Institute for Catholic Thought and Culture, I will confess freely that I don't think that I am improving much on Aquinas' definition. So it depends what translation you use, but Aquinas said that law is an ordinance of reason for the common good made by him who has care of the community and promulgated. I do want to, in fact, associate myself with Aquinas' view of law. Now, what you'll notice or what you can or should notice about my definition of law is that it comes in two parts. First, a set of commands. Now, that's significant for two reasons. One, the set part of the set of commands, because I want to think of law as a whole, the legal system as a whole. I think the only way to get the concept right is not to think of laws individually, but to think of the legal system as a whole. And as I'll say in just a little bit, there's going to be implications of that, naturally. Second, in the first part of set of commands, so the second part of the first part, there's didn't even plan that one. There's command. Now, one of the towering figures of legal philosophy in our times, second half of the 20th century, but whose legacy is surely enduring, is Hart. And one of the big achievements, quote unquote, of Hart in his very important work, The Concept of Law, which I am attacking, is the idea of his rejecting the traditional understanding of law as command in favor of rules. I'm not going to get into all those details here, but outside of this, my tiny little subfield, you wouldn't notice this, so I'm pointing out to you that speaking of law as command is actually a pretty unpopular opinion, as we say these days, a hot take, as it were. And so I'm thinking of the legal system as a whole, and I'm thinking of command as the central case of law. The second part of my set of commands oriented to the common good is the common good part. And there, I'm saying something which is squarely within the natural law tradition, that law is inextricably normative. That our understanding of law, our definition of law, is not separable from thinking about morality. That the definition of law has to include moral criteria. The way I choose to do it, again, is to say that for law to be law, a legal system as a whole, it has to be oriented to the common good. Which brings us to Nazi law, to the other kind of law that legal philosophers love to talk about. And the reason legal philosophers love to talk about it, and love to talk about it in this exact context, is because Nazi law seems really, 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 really bad, but it sure looks like law. Right? So Hart, and he would not say it this way, he would say it much more elegantly, he would say, drop me in the middle of Nazi Germany, and I can look around and point to laws, and it's while it is completely uncontroversial that some of these laws are monstrous, they're completely unjust, having no moral justification, at the same time, I can completely recognize them as laws. And to deny this is simply to deny what's in front of your face. There is an ancient maxim that even goes back even before Catholic thought on law, even before Augustine and Aquinas. I checked my Villanova box. Even before Augustine and Aquinas, that says an unjust law is no law. And if that's right, then what is Nazi law? Surely we can agree, again, uncontroversially unjust. And yet, Hart says anybody with eyes to see can see that there is law in this setting. So what exactly is going on here? So positivists, like Hart, want to reject, positivists who want to separate law and morality, briefly, positivists want to, in a certain way, reject the ancient maxim, an unjust law is no law, because again, they think that they can identify law in any setting without respect to the justice, without respect to the moral content of that law. Drop me in antebellum American South, drop me in Nazi Germany, drop me wherever it is. I can recognize the Fugitive Slave Act as law. It's right there. Everybody treats it like law. It's sure acting like law. What's the problem? And that's what's motivating the book. So what's motivating the book is seeking to define law against Hart, in other ways against Raz, who I won't discuss as much today, against the positivists more generally, in favor of this natural law approach that links law to the common good, but also recovers the older positivist way positivists' way of thinking about law as command, and not the way Hart thinks of it as rules. And so now I can turn to part two, which is some reasons why the book might matter for scholars, again, for those who have any kind of academic interest in the subject. And again, the next part will be for the rest of you who are generous enough to be here. It is certainly the case that positivism, legal positivism, dominates the field and has for a very long time, and certainly seems unassailably ascendant since Hart writing The Concept of Law and Joseph Raz's many books that followed that. As much as I would love if people would not necessarily read, but own a copy of the book, I know there may be copies here, but also there's a 20% friends and family discount. Thank you, University of Notre Dame Press. I owe them a lot as well, and I'm hustling books only, not out of vanity, but truly out of gratitude to the press for the opportunity to publish it. As much as I would love for people to have my beautiful book on the shelf, and it really is. Should take it out first. University of Notre Dame Press made a beautiful, beautiful volume, perfect for sitting on the shelf. So it even feels nice. It's got like this kind of people. Someone says like, "Oh, that texture, it's so velvety." I was like, "I know. I don't know what they did, but it's great." They also divined that I'm actually not a fan of book jackets, so somehow I got a hardcover with no book jacket. It's like best of both worlds. I don't know. I lucked out. The press, amazing press. As much as I would like you to read my book, if there's one takeaway, one reading assignment takeaway, it would be John Finnis's article, Law and What I Truly Should Decide. And it's even better than that because I have students, so I know how it goes. Just part one of the article, not even the whole article. In that article, Law and What I Truly Should Decide, Finnis argues, I think, decisively against positivism. He says that you cannot understand law without its purpose of justice, or in my words, without its orientation to the common good. And to think of law and law that is unjust fails to be law in the same way that a bottle of poison fails to be medicine. You can put a label that says medicine on a bottle of poison, but it simply isn't medicine. So you can call it whatever you want, but when you separate the thing from its purpose, it simply isn't that thing anymore. And so in that sense, Finnis defends the ancient maxim of an unjust law is no law. It imitates law, it resembles law, but it simply isn't law. And so this is my intervention into this debate between, let's say, legal positivists and natural lawyers. And in a way, and I may be a little bit extreme, but I think I go even further than most of the other non-positivists in my rejection. So Finnis, in a certain way, while not adopting positivism, takes a lot of Hart on board, takes a lot of Raz on board, and far be it for me to criticize Finnis in any way, but I think that actually the central ideas that they give us in legal theory should be kept even further at arm's length. And to highlight that, I will just turn to one other piece of literature, a little bit less well known. This one, not Horton Hatches the Egg, but Dr. Seuss's Did I Ever Tell You How Lucky You Are? I think an underappreciated work. The doctor of Dr. Seuss is actually a PhD in analytic jurisprudence, for those who didn't know. And somehow, I guess he was early to reading the concept of law, which came out in, what was like 60, 61, I think, something like that. So 1973, here's what Hart wrote. Hart's first name is Herbert, for those who don't follow jurisprudence trivia. And here's what Seuss wrote. Just suppose you were poor Herbie Hart, who has taken his thrombodimulator apart. He never will get it together, I'm sure. He never will know if the gick or the goor fits into the scrux or the snux or the snore. Yes, Ducky, you're lucky you're not Herbie Hart, who has taken his thrombodimulator apart. And this is the magnificent illustration of Herbie Hart having taken the thrombodimulator apart and never, ever possibly getting it back together. And again, Seuss isn't subtle here, right? He just calls him Herbie Hart, right? We're not pretending who we're talking about here. And whether or not he ever read the concept of law, I don't know, but it works. Because my claim is that Hart's attempt to dissect the concept of law, to take it apart, and then put it back together in a way that works, leaves him in a situation where it cannot ever work again. That there are pieces inside of his reconstruction of the concept of law that make it fatally flawed, and therefore all of the many, many decades of scholarship that follow that make that scholarship built on a flawed foundation. To tell you briefly what that is, in Hart, I think he's wrong about commands and rules and sovereignty and democracy and a lot of things. But to highlight this one point, here is Hart's central insight, certainly one of his central insights. And that is that, back to the traffic light, that there is the difference between a law and a mugger. He says that, that until now, we have thought of law, positivists, the other positivists, have thought of law from the external point of view. So you imagine hovering over an intersection and seeing a light turn red, and seeing vehicles stop at the red light, seeing a light turn green, seeing vehicles go. And he says this is seeing the law simply as a prediction of regularities of behavior. That law is telling you how people will behave, how people might behave, but what it's not telling you, what it's not showing you, this understanding of law, is the internal point of view. From the perspective of the person under the law, what is their experience of the law? He says, and here's the differentiation between the law and a mugger. He says that when a mugger holds a gun to you and demands your wallet, you are obliged to give over your wallet. Obliged in the sense of like, this is what you want to do if you don't want to get shot, but not obligated. Obligated, right? What do you mean not obligated? Well, if you somehow get away without turning over your wallet, you haven't done it. Nobody look at that. You've done something wrong. You failed in some obligation to the mugger to hand over the cash. You haven't done that at all. You are obligated. You're obliged, but not obligated. As opposed to with the law, people don't experience and don't treat the law as a mugger. They don't stop at the red light because there's a gun to their head. Now, it's true there is punishment for running the red light and all of that, but actually, in a way that's very different, they understand themselves to have an obligation to obey the law, which is distinct from being obliged. This is Hart's gift to us, the internal point of view. Now, in a certain way, Hart seems very correct about that people treat the law as though they have an obligation. People may, in fact, have an obligation. The problem is that Hart, as a committed legal positivist, wants to separate law and morality and cannot say that law depends on any normative criterion for its validity as law. As a result of this, if law cannot be defined, necessarily must be defined without normative criteria, or at least not necessarily with normative criteria, would be the better way to say it, then I don't think he can account for why law is connected to obligation. So point one of Hart is we can see and define law without respect to normative criteria. That's why we can see Nazi law as law. Drop me in Nazi Germany, drop me in Midtown Manhattan, it doesn't matter, I see law. Because it doesn't matter what the content is, it doesn't matter if it's just or unjust. And yet at the same time, people treat law not like a mugger with a gun to their head, but treat law as something that obligates them. But of course, the only way to make sense of that obligation is if people understand themselves to have an obligation because of the normative content of the law, because of the justice built into the law. But if law is something that exists independent of justice, then there's no reason, unless everyone's under a mass delusion, as I say, what would be the reason why anybody would treat law with obligation? Again, you can't say, oh, because of coercion, because that's just the mugger again. That's just obliged. I think I'm going too long. Where are we on time here? Is somebody keeping track of time? Okay, sorry. And this, to come to civil obedience, I think that Hart, one of the examples that Hart likes to use throughout the book is the post-war German trials of war crimes committed by Germans during World War II. Hart says, well, the problem with these is that the conundrum is that we're putting people on trial for laws, for things that they did when those things were legal. They were following the law. How can we put people on trial for following the law, for just following orders? Now, there's a certain truth to that, but in a way, I think Hart can't make sense of his own example, because if law is disconnected from morality, if law is not based in justice, if we can't account for any kind of obligation to obey the law, then what's the big deal? The people followed the law without any obligation to do so, and so certainly they're accountable. Or at least more accountable. If, on the contrary, we understand that they did have a moral obligation to obey the law, albeit a moral obligation that was possibly defeated by other moral obligations, then we have a real conundrum. Right? So putting people on trial for obeying the law when you don't think the law confers any obligation is not as big of a deal as putting people on trial for following the law when you think they did have an obligation to obey the law. And so the way that I make sense of civil disobedience is saying that, in fact, you do have an obligation to obey the law just because it is the law. And sometimes that obligation is defeated by stronger obligations not to obey the law. Kill the Jew? Well, I can't do that. Well, it's the law. Yeah, but I have a stronger obligation not to do that. And that's and I think this also makes sense of the normal feature of the standard feature of civil disobedience, that you accept the punishment, right? Martin Luther King isn't breaking the law and running and hiding as a fugitive. He's accept, right? His hands come out for the handcuffs to land in Birmingham jail. And so that's what I'll say about Hart and the scholarship. More briefly now, because I've gone long, which always happens, is a few things that the rest of us might think about going into election season, perhaps. The connection between law and the common good, and for me, more another unpopular opinion I have is I don't make the distinctions as much between political obligation and legal obligation that other scholars are very concerned with. I think they're essentially the same thing. And so thinking about politics and law as the common good is first, hopefully descriptive. Right? It's easier to get along with our political opponents if we remember that we are opponents with competing visions of the common good, and not just opponents competing for greater slices of a shrinking pie or something of that sort. Now, it doesn't always mean it's the case, right? Maybe you actually think your political opponents are trying to destroy the country, in which case I will say that the common good is a good prescriptive reminder, if not descriptive, that our goal in politics should not be perhaps total victory as in war, but a seeking of the common good together. Lincoln is probably the American statesman most famous for saying, the North and the South are going to have to live together again after the war, and so let's not forget to seek the common good of the other. But I think that's certainly not an explicit point of the book, because I stay kind of narrowly academic and non-political in the book, but I think that's there. Conversely, perhaps, Augustine, again, famously said that kingdoms without justice are great robberies. And so the reminder of the connection between law and the common good is a reminder that a state not oriented to the common good is a tyranny. And in our day, we are blessed with the opportunity to contemplate that as well. When is a state no longer in whole or in part oriented to the common good, and instead a tyranny? And then finally, a third point, which again, apologies for rushing through, the relationship between democracy and authority. In considering authority and obligation in the book, I turn to other examples: moral obligation and religious obligation. Moral obligation, I call maybe cheekily reasons without commands, right? So those of us who affirm the truths of the natural law know that you can have reasons to do things that are right or not to do things, reasons to do things that are right, reasons not to do things that are wrong, independent of any command by any sort of authority to do so. Things are intrinsically right or wrong. Religious obligation, I think in some cases, can be the opposite, commands without reasons. And I think it's especially interesting to raise that in this setting, to think about how that fits in with Catholic thought. Catholic thought, perhaps more than any other tradition, is, I say this as a compliment, focused on the intertwinement of faith and reason, and the inescapable intrinsic goodness of God that fills everything that he does and commands. And yet I think there's perhaps thinking about the other side, thinking about commands without reasons, things that God says to do just because. And in Judaism, we are chock full of those. Thinking about can point us to thinking about the goodness of obedience to God just for its own sake. And is it perhaps sometimes a gift of God to do some things when we don't understand? And I say a gift of God because the one thing, and I don't know if this would be like a controversial final point, but the one thing an act of following God doesn't have when you know the reason, and it's a good reason, is it doesn't have obedience. right? You're doing it because you have a reason and because it's a good reason. And that's a good reason to do it, independent of the fact that God commanded it. But if you're doing something commanded and you don't know the reason, or there isn't a reason, that is truly obedience. And that's not something that sounds good to our small d democratic ears. And I'm not suggesting, I see the opposite of the book, that wouldn't make sense to us if a government said, we're commanding you to do it just to do it. But I think it turns out, or I think I have evidence that there is that the book may provide that kind of food for thought. I'll close. I have a friend, a former Villanova student, who's a pilot in the Navy now. He flies, well, now he trains other people, I guess, to fly Navy helicopters. And I'll close by what he texted me. And this really is vanity, so forgive me. But if it inspires somebody else to place the book on a shelf, it's worth it. He writes to me, from what I've read so far, I found it incredibly thought-provoking for my faith and for parenting of all things, to end where I started. Specifically for one of those thoughts, how do I teach Levi, it's his young son, how do I teach Levi that he is a being under authority without subverting that very authority? He is under my authority, yes, but ultimately that is granted by God, as is the state's authority, so his words, not mine. So I need him to begin to grasp that concept even at a young age. I've tended to hold him to my word and then explain. Don't touch the stove because you may get hurt. But I'm wondering if that is teaching him to obey authority as an advisor and not out of obligatorinity, as he wrote, thus stripping the authority of, it's hard to make these new nouns sometimes, thus stripping the authority of the hold that it rightly has. I'm wondering if the because I said so is better as an impulse, but then also adding in the, and also so you don't burn yourself to build street cred. Or with my faith, this last two sentences of the text, or with my faith, I've been pondering the nature of obeying the Lord's commands when I understand why they are there, versus when I have no idea what the heck, sorry for the French, why the heck I need to do that thing. It's a matter of obligation and authority, not necessarily a matter of understanding and knowledge, although the Lord is often kind to grant the latter too when asked. Now, caveat, he's Protestant, so you know, but anyway, I'll leave you with that thought. A variety of things to inspire you to crack the book. Thank you so much, and sorry for going a little long. Thank you.
So, good afternoon. I'm so delighted to have been invited to engage with and offer comments on this truly outstanding book. I took philosophy of law as an undergraduate student and then again in grad school. I'm not a strict legal philosopher, but I returned to the literature with which Danielle is engaging over and over again. And I have never read as lucid a retelling of the existing theories as is in Danielle's book. Nor have I ever read as compelling a way out of the thicket. So the book is just a massive accomplishment. It's clear, it's elegant, and it says genuinely new, interesting, and persuasive things in an area that has been mired in debate. So I will join Danielle's exhortation to you to buy the book. Buy it for yourselves, assign it to your students if you teach students, give it as a gift for the holidays, hand it out in Halloween. No, the book is really marvelous. And I'm going to eventually launch into a couple of questions that the book raised for me, but even before I get there, I'm going to go off script a bit because I was really gratified to have Danielle begin and end with the experience of parenting, with the appeal to his own sons and then his friends' child, because the image of law that the book conjured for me was really akin to the experience of being a parent. I know that this is not an experience that some of you have had, but the best kind of parenting, as I came to learn the hard way, was the kind of parenting that inhabits authority, that allows one to actually offer one's kids commands in some instances on the thought that it's not an abuse of one's power to do so, that one is, genuinely in a position to see what is good for the kid in a way that kids just often aren't in the position to see for themselves. And I'll illustrate this with a little anecdote. As I said, I came to this understanding of parenting the hard way. My initial approach, which was sort of the fad at the time that my kid was young, was to instead let your kids learn for themselves, expose them to quote-unquote natural consequences. So here's how this works in action. When my kid was 4, he resisted all winter clothing, like he was going to have none of it. So it's, freezing cold day, Nathan, put on your jacket. Nope. Okay, fine, be my guest, you go go outside in your t-shirt, let's see how that works for you. And sure enough, we go outside, I'm supposed to walk into school. School's like a 10-minute walk away, and I'm expecting at any minute for him to be like, let me go back and get my jacket. But no, this kid is like, the battle of wills is one that he will win no matter what. And so, so much for natural consequences. And on a second occasion, because I was not a quick learner, so I continued with this natural consequences way of going, my father, who is a lawyer, happened to be visiting, and he was completely appalled by this parenting strategy. To the point, and I should say, my father actually did youth protection, protecting young kids from parental neglect. And had I been in his jurisdiction, I think he might well have contacted the authorities, because I was not being the authority that I ought to have been, right? And what I ought to have been doing was just what Daniel describes as the function of law, right? I ought to have been issuing commands with the knowledge that in doing so, I was taking off the table the prerogative and the necessity of having my kid judge for himself what's the right thing to do on any given occasion, and instead cultivating in him trust that I was, going to, in general, be oriented toward his good. I wasn't going to always and in every instance know exactly what the right thing was, and I certainly made my fair share of mistakes, but nonetheless, on the whole, my authority was justified insofar as it was aimed at his good, and I was most of the time capable of ascertaining what that was. All right, so again, this is a vision of law that sees law as benevolent and wise and really effective at steering us toward our common good. I found, for the most part, that I was entirely on board with Daniel's account, but I didn't come here only to praise the book. I do want to raise a couple of questions, and they're connected to this idea of, how the common good fits into the picture. So, of course, if law is a set of commands oriented to the common good, then we have to trust that our legislators are going to be capable at arriving at the right sense of what the common good is, right? The people who make the law have to have some insight into what is the common good. Now, Daniel says very little about what the content of the common good is, other than to connect it to human flourishing. So the common good aims at our flourishing. But what does flourishing consist in? Daniel doesn't really say. Now, I want to be clear that that is not a failing of the book. I wouldn't expect Daniel to have offered an answer. As I said, what Danielle has done is to offer an elegant, compelling account of law, and it's really more than enough of an achievement. It would be greedy to want any more. But I do think the emphasis on the common good puts pressure on the question of democracy's role, which is something Danielle does discuss. And my worry is that Danielle's discussion might still give democracy short shrift. So his discussion of democracy focuses on consent. Other theorists argue that law is legitimate only if it is the product of the people's consent, and democracy secures that consent. Danielle argues in response that consent is not in fact necessary, and I'm convinced by his arguments. But I worry that democracy might be important for a different reason, namely that it ensures representation from a wide and diverse set of people. This wide and diverse representation becomes especially important when we're thinking about law as aiming at the common good, because the populace, with all its different kinds of people, might well arrive at a more inclusive conception of the common good than other forms of political organization could. And insofar as Danielle's account denies that democracy is necessary for law, I worry that it has the potential to affirm a system of law that aims at a distorted or maybe even deficient conception of the common good. At any rate, I would have liked Danielle to say more about the role of the people as a whole in formulating the content of the common good. My second question, or question mark, arises in response to Danielle's account of the bindingness of law. So one of the signature achievements of Danielle's work, as I said, is that it provides a justification for why law, as such, obligates us. And again, in his simple and elegant phrase, law is a set of commands oriented to the common good. And as he said in his remarks, what matters is not that each distinct command aims at the common good, but instead that the set as a whole does so. So long as law on the whole aims at the common good, then we have at least a prima facie presumptive obligation to obey each and every law, even the ones that strike us as inadvisable. Now, as Danielle also said, his vision is compatible with civil disobedience, and he has a really nice discussion, in fact, showing how the possibility of civil disobedience depends on the obligatory nature of law. Civil disobedience couldn't perform its function of protesting the law were it not the case that there was an obligation to obey. The idea can be read off the term itself. Disobedience sets itself against obedience. That's how it makes its point. But there's a related legal phenomenon that it isn't clear to me that Daniel's account can accommodate. And I'm thinking here of recent Supreme Court cases where individuals have asked for conscientious exemptions to governing laws. So as some of you may know, in a case called Burwell versus Hobby Lobby, you had the religious owners of Hobby Lobby craft stores who didn't want to have to pay for their employees' contraception. Or in a different case called Masterpiece Cake Shop, there was a religious wedding cake baker who didn't want to have to bake a cake for a same-sex wedding. Now, what's important to note for these purposes about the litigants in these cases is that unlike the civil disobedient, the challengers in these cases were not saying that the laws themselves were unjustifiable. They weren't saying these laws are immoral. They didn't contend that no employer should be made to subsidize contraception or that no baker should have to bake a cake for a same-sex wedding. So they weren't undertaking to protest the law as the civil disobedient is. Instead, they were only seeking to have the law in question not apply to them. They wanted an exemption. The laws that they challenged are arguably aimed at the common good. In the Hobby Lobby case, the governing law was one that said that in general, employers had to subsidize their employees' health insurance, right? That looks to be at least compatible with the common good. In the wedding cake baker case, the governing law was the one that said, in general, if you operate a retail store, you can't discriminate on the basis of sexual orientation, among other things. And there's reason to think that it's not just those particular laws, but the overarching legal regime of which those laws were a part. Federal law in the case of Hobby Lobby, or the law of Colorado in the case of the baker. These were systems of law that were oriented to the common good. And so insofar as these are generally decent laws that are part of a generally decent legal regime, it wasn't clear to me whether, and if so how, Daniel's account could make sense of what these litigants were asking for, namely to not have the law apply to them. Or put another way, Daniel's account of the obligatory nature of law would seem, I think, to leave no room for legal exemptions. That would be a really striking outcome of the book, of the account. I'm not sure if Daniel would endorse it. I'm really curious to know whether he would. And it's just one among many places where I want to know more. And I hope that my questions, along with Evelyn's, will spark ideas for a follow-up book, given the enormous significance of this one and also Daniel's really deft and engaging writing. I would buy that second book in a heartbeat. I would give it to my friends and relatives for the holidays, et cetera, et cetera. But yes, please join me in just congratulating Danielle.
So thank you to the organizers for putting together the event and for this invitation. I've had a lot of fun so far. And I wish I had the space here to applaud the many accomplishments of this book, but instead I will content myself with highlighting just a small subset of those and then posing a few comments and questions in the hopes of generating some discussion. This book's primary aim and chief virtue is a return to foundations. It identifies a general problem in contemporary analytic jurisprudence, a problem of obligation, or by the other side of the same token, a problem of authority. And it diagnoses this problem as downstream from how legal philosophy has of late conceived of what law is and whence it receives its obligatoriness. And so the book first embarks on a foundational critique of the concept of law found in Hart and Raz and their disciples. In the preliminary chapters, it dispatches with ease a tangle of ideas that have grown up around these particular positivists' conceptions of law. In cutting through this brush, the book offers an alternative route with straightforwardness and clarity, which is laudable in any book, but which is especially elusive and to be prized in a book which honestly engages with those muddier debates of contemporary legal theory. The book instead grounds the authority and obligation of law in law's nature as commands oriented to the common good. Along the way, and particularly in the later chapters, the book also anticipates many possible objections to this formulation, not only from those academic positivists, but also more generally from the point of view of liberal democracy, which from its inception tends to balk both at the common good, or at least a substantive summum bonum, or really justification by final end in any sense, as well as the possibility of authority being justified by anything other than democratic legitimism. It's these possible objections, rightly anticipated in the book, which highlight the originality of the work by pointing out how this definition of law appears, at least, to depart from other more typical legal theories produced by liberal democracy, although they might be compatible with liberal democracy itself. I want to turn primarily to this second half of the work, which contains this original reframing. My comments fall into three main categories. First, on the role of the lawgiver and the relationship between the authority of law and the authority of the lawgiver. Second, I'll turn briefly to the book's requirement that an authoritative system of law be on the whole oriented to the common good, as opposed to imposing the common good criterion on individual laws. And then third, I'll turn to the relationship between legal obligation and other forms of obligation. So first, on this question of the lawgiver, or to use a traditional concept, the efficient cause of the law. In two key parts of the book, deliberately exclude the possibility of the authority of the lawgiver as generative of the authority of the laws. The first denies the old guard theorists as law as command, which grounds law, the obligatoriness of law, in the coercive force of a sovereign. Think Hobbes. The second is an extended denial that the authority of the law trades in democratic legitimacy. This I take to be a major insight of the book. The democratic legitimist insists that the duty to obey the law must hinge in large part on the notion of consent. Through some original or tacit or explicit or mythical act of consent, we the people are true authors of the law, and thus in obeying the law, we can be said to be just obeying ourselves. We are literally autonomous, self-legislating. This book discards this ground of obligation in the justification of a democratic lawgiver, or the efficient cause of the law. The authority of the demos as lawgiver is justified by a logic external to the definition of law here. It may as well be the form of government, it being democracy, best equipped to ensure the common good, but this is in a sense orthogonal to the question of legal authority. This approach to democratic legitimacy implies a much needed and subtle critique of the notion that bare consent of the people can do all that we want it to do in bearing the entire weight of legal obligation. Still, I'll note here that it isn't clear to me that rejecting democratic legitimacy requires more generally bracketing the authority of the lawgiver from the authority of the system of the law entirely. I'm not obligated to obey just any command made for the common good, say the command of the CDC to get vaccinated for a novel virus, but only commands made by authorized commanders, perhaps Congress. This is not to say that this definition of law ought to adopt any one particular justification of sovereign authority. I'm happy to bracket particulars here. But still, it seems to me at least that obligation might emerge not only by virtue of the final cause of the law, but also by virtue of its efficient cause, to borrow a phrase from Thomas, the one who has care of the community. And as a partial aside, this point also brings to mind some early modern debates among natural law philosophers about the necessity of the lawgiver in the imposition of true obligation. Secondly, I'll turn only very briefly to the common good. I'll say that I very much appreciate the hesitancy the hesitancy to foray into vexed and rarely fruitful debates about the specific nature of the common good. So instead, I'll raise a question about what it means for a system of law to, on the whole, be oriented to the common good. There seems to me to be a few ways of specifying whether a system of law on the whole is oriented to the common good. One might say that the Constitution, the way that is basically procedurally oriented to the common good. One could also say that the laws produced by society generally on the whole aim at the common good. Either one of these two options has some difficulty, though not insurmountable. If the former, then the criterion of aiming for the common good via a constitutional arrangement seems to smuggle in the justice of the lawgiver. And if the latter, the general orientation of the common good, is here an emergent quality of the laws as a whole, it appears the theory is somewhat less content independent than advertised. I don't think this is a devastating problem for the coherence of the theory at all. But it does raise kind of an interesting wrinkle to questions about how to define the breaking point of emergent orientation to the common good. One thinks of Rawls as basically just society and where we draw the line. And then finally, I'll turn to the question of legal obligation, the relationship between legal obligation and other forms of obligation, like moral, religious, and possibly natural law. Now, a full account of this relationship is beyond the scope of the work, but I couldn't resist because the book's use of analogy of the relationship between obligations nevertheless raises interesting and evergreen questions of conflicting obligations as raised by Amy. But how might we understand various other obligations and adjudicate among conflicting or overlapping obligations on this account of legal obligation? On this subject, I'll pose just one question that pushes beyond the book itself. How do we understand moral obligations outside of civil law? Are they truly binding? The definition of obligatoriness found here seems to require that they be. But how similar is this obligation to legal obligation? The book notes similarities, but draws clear distinctions. How one answers this question, to me, seems to be relevant in determining the relationship between different obligations in an established polity, particularly if you are propounding a natural law theory. I also take this to be a major dispute between the natural law originalist position and the recent upcropping of the so-called common good constitutionalists, which suggests that the natural law partakes in the nature of law ipso jure and is binding or obligatory much in the same way as civil law is binding. This is also possibly related to the question of the lawgiver and the relationship between commander and obligation. So I'll end there. I echo Amy's call for a second book. I can't wait to read it. Hopefully we'll have just the same matte cover and recommend buying this one. Well, it's the only one out.